I think Harry shouldered most of the bill because of his stupid outburst. I mean, what an idiot.
What an idiot indeed.
Prince Harry is in serious financial trouble right now, and most people have completely missed why. This wasn't just a courtroom loss. It was a catastrophic, foreseeable collapse that people inside the royal family apparently saw coming before Harry ever filed a single claim. The case involved 7 claimants, 1 powerful publisher, and legal costs now reaching numbers that are genuinely staggering. Someone close to the palace has already used the words, "What an idiot." And the reason they said it isn't simply that Harry lost. It's what the details of exactly how he lost reveal about a decision he was warned against making. The gavel came down on a Tuesday morning in London's High Court, and within minutes, Prince Harry had already decided he didn't like what it said. 10 weeks of testimony, 436 pages of written judgment. Mr. Justice Nicklin had examined every thread of the case, weighed the witnesses, assessed every contested article, and delivered a verdict so comprehensive it left no interpretive room. He dismissed all 97 claims, every single one. The ruling was precise and unsparing. The claimants had failed, the judge found, not because their suspicions were unreasonable, but because suspicion is not proof. The court specifically rejected the argument that, simply because information was private and because Associated Newspapers could not positively explain how it had been sourced, the articles must therefore have been unlawfully obtained. That distinction between what you believe happened and what you can actually prove is where this entire case collapsed. And Harry's response? The statement was released within 20 minutes of the judgment dropping. 20 minutes. Nobody reads 436 pages in 20 minutes. Nobody. Yet there it was, Harry calling the ruling a complete and obvious whitewash. Now, that phrase is doing a lot of work. It signals fury, yes, but it also signals something else. It signals a man who had decided the outcome before the judge had finished explaining it. After years of preparation, millions spent, and weeks in that courtroom, he'd already written the ending he intended to tell the world. But to understand why people inside certain circles are now quietly using the word idiot, you first need to understand exactly who walked into that courtroom alongside Harry and what they were all actually claiming. 7 claimants in total. Sources say the lineup was deliberately constructed to project moral weight. Sir Elton John and his husband David Furnish, Baroness Doreen Lawrence, mother of murdered Stephen Lawrence, Elizabeth Hurley, actress Sadie Frost, and former Liberal Democrat MP Sir Simon Hughes. Names chosen to make Associated Newspapers look like an institution that preyed on grief, celebrity, and public service alike. Together, they brought 97 articles to court, each one alleged to have relied on information obtained through voicemail interception, landline tapping, and blagging, the practice of fraudulently extracting private details from third parties. Blagging sounds almost quaint until you understand what it means in practice. Someone called a hospital, a bank, a phone provider, pretended to be someone they weren't, and fed that information into a story. That was the allegation, not speculation, not a general complaint about press culture. Specific, named articles, specific, alleged methods. A&L's position was equally specific. Every article had a lawful explanation. Press officers, spokespeople, freelancers, prior reporting. 2 completely opposing accounts of the same 97 moments. So which one did the judge believe? That's where this entire case either holds together or falls apart. And here is where the case actually collapsed. Because the central question was never whether Harry and the other claimants felt wronged. The question was whether they could prove it. And sources close to the proceedings suggest that distinction, which sounds simple, was the one Harry's legal team consistently underestimated. The legal standard in English civil law is the balance of probabilities. More likely than not, that's all they needed to clear, and they still couldn't do it. Mr. Justice Nicklin was explicit in his 436-page judgment. The claimants suspected unlawful sourcing. They built a case around the logic that if information was private and A&L couldn't fully explain how they got it, then the method must have been unlawful. The court rejected that argument completely. Suspicion is not proof. That's the verdict, distilled to 5 words. Now, A&L's defense was methodical in a way that Harry's team genuinely failed to anticipate. For each of the 97 articles, A&L produced a plausible lawful explanation. Press officers briefed, spokespeople talked, freelancers sourced, prior reporting was recycled. People connected to the claimants spoke, sometimes without being asked twice. None of that is glamorous. None of it sounds like the sinister machine the claimants described. But individually, each explanation was credible. And collectively, they built a wall. The claimants couldn't dismantle because dismantling it required documentary proof of unlawful acts, not the inference that unlawful acts probably happened. That's a genuinely difficult evidentiary threshold when the alleged methods leave no paper trail by design. But here's what makes this particularly damaging. Harry's team knew, or should have known, that standard going in. The gap between what they could allege and what they could actually evidence was flagged well before this case reached trial. They pressed forward anyway. And the judge found the case fell apart, not on one article, not on one claimant's evidence, but across the board. Which raises an obvious question. If the legal case was this fragile, who was paying to hold it together? And for how long? Because the answer to that is where the story gets genuinely brutal. So here is the number that changes everything. A&L spent over $50 million defending this case. £50 million, accumulated across years of preparation, disclosure battles, and a 10-week trial that sources describe as one of the most expensive privacy actions ever fought in the English courts. And now they want it back. The interim payment A&L is seeking, the immediate ask before the full costs assessment even begins, is approximately $10 million. That is the opening figure, the floor, not the ceiling. But here's where it gets genuinely complicated for Harry's side. His team has put forward an insurance position that sources suggest covers roughly $16.2 million in total cost exposure across all the claimants. On the surface, that sounds like it might be enough to handle an interim demand. It isn't. Not even close. Because A&L is also pursuing what is called an indemnity costs basis. Under standard costs rules, a winning party recovers a proportion of what they spent. Under indemnity basis, the recovery can be substantially higher, and the burden shifts onto the losing party to justify why the costs claimed are unreasonable, rather than onto the winner to justify why they should get them. It is a meaningful legal distinction, and it could push the recoverable total significantly beyond the headline $34.5 million figure A&L cited to the court. Now, run those numbers side by side. Insurance coverage of $16.2 million. A cost claim that could realistically land somewhere between $18 million and considerably more, depending on the indemnity assessment. That is structural exposure. And it is spread across 7 claimants, which raises a question nobody has answered publicly yet. How is that liability divided? Sources close to the proceedings suggest the court will need to address whether claimants share proportional exposure or whether individual positions vary based on their specific claims. Harry brought the most articles, the most allegations, and by every account was the most prominent face of this litigation. The arithmetic of that is something his legal team will be working through very carefully right now. But here is what makes this worse than just a financial problem. The costs hearing is still pending. The final number has not been set. The insurance gap is not resolved. Every day this drags forward, the exposure sits there, uncontained. And before any of that could even be properly processed, Harry did something that may have made the judge's eventual cost decision considerably harder on him. Within 20 minutes of the ruling, before any human being could have read 436 pages, he issued a statement calling it a whitewash. What happened next almost certainly made everything worse. No human being on Earth had read 436 pages in 20 minutes. The statement was pre-written, pre-loaded, and fired before anyone actually knew what the judge had said. That is a strategy. And it was a catastrophic one, because what Harry effectively did was stand in front of Mr. Justice Nicklon's court, a court of the king, his own father's court, and publicly accuse it of institutional corruption before the ink was dry. He didn't critique the outcome. He didn't say he was disappointed. He declared the entire proceeding a stitch-up, deliberately, on the record. Now, judges are not supposed to be influenced by public statements. That is the official position. But costs decisions are not purely mechanical. They involve judicial discretion. And one of the factors a judge is entirely entitled to weigh is how a losing party has conducted themselves throughout proceedings, including publicly. Sources close to legal observers say that issuing a pre-written attack on the court's integrity within minutes of a ruling is, at minimum, not something that makes a cost judge feel generous. There is a deeper problem here too. The statement did not just insult the judge, it quietly confirmed something A&L had been arguing throughout the case, that this litigation was never purely about legal remedy. It was about narrative, about leverage, about using a courtroom as a platform to keep a war with the British press alive. Harry's team had very limited options once that verdict landed. They could have said nothing. They could have issued a measured, legally careful response. They chose the scorched earth version instead. And that choice almost certainly hardened what comes next. But Harry didn't make that choice in isolation, because there are people who had a very clear interest in him staying in that courtroom, fighting that fight, regardless of what it cost him. Now, A&L's written costs argument doesn't just ask for money, it makes an accusation. Sources familiar with the submission say A&L explicitly named Hacked Off, the press reform lobbying group founded in the wake of the phone hacking scandal, and argued that Harry and his co-claimants were, in effect, useful idiots, recruited not primarily to win a legal case, but to sustain a public pressure campaign against the British press, to keep the narrative alive, to keep the wound open. The evidence A&L cited for that charge is genuinely difficult to dismiss. The pre-trial press releases issued on behalf of the claimants were sweeping. Bold claims about systematic unlawful behavior, institutional corruption, a cover-up stretching across decades. The kind of language designed to move opinion, not to meet a legal threshold. What was actually argued inside the courtroom was considerably narrower, more cautious, because the legal standard demands proof, not assertion. And when you strip away the press release version of this case, what remained was thinner than the public had been led to believe. That gap between what was announced and what was proved is exactly what A&L is pointing to now. If this litigation was always partly a PR operation dressed as a legal action, Hacked Off had every incentive to encourage it regardless of outcome. A loss still generates headlines. It still puts the Mail on trial in the court of public opinion, even if it wins in the actual court. Harry bears the cost. Hacked Off absorbs none of it. So, the question worth asking is this: when Harry took that stand and faced cross-examination, how did he actually perform? Because the judge's findings on that are far more damaging than the verdict alone. The judge's findings on Harry as a witness were not simply unfavorable. They were specific, detailed, the kind of credibility assessment that doesn't disappear quietly into a 436-page judgment. It gets quoted. Mr. Justice Nicklin found that Harry's evidence was, in places, inconsistent, that his account of certain incidents shifted when pressed, that the confidence he projected publicly was not consistently matched by what he could actually demonstrate under oath. Sources close to the legal proceedings say that when cross-examination moved into granular detail on specific articles, Harry's recall became selective in ways the judge noticed and recorded. Now, that matters enormously. Because, in a case built almost entirely on the claimant's subjective experience, on what they believed happened, on what they claimed to know, witness credibility wasn't a peripheral issue, it was the entire foundation. And the judge, methodically and without drama, quietly indicated it wasn't solid. But here is where the damage extends far beyond this courtroom. Harry has spent the last several years constructing a very deliberate public identity: the truth teller, the witness, the man who came forward when everyone else stayed silent. Spare, the Netflix documentary, the Oprah interview, every single one of those was premised on one thing: that when Harry speaks, you believe him. A finding by a high court judge that his testimony was unreliable doesn't just hurt this case, it retroactively casts a shadow over all of it. That is precisely what some inside the institution have been waiting for. Not to attack him openly, but to let the record speak, because a judge saying it carries a weight that no palace briefing ever could. And Harry cannot appeal a credibility finding the same way he might appeal a legal ruling. It simply exists now, in the public record, permanently. Which brings the question, if his credibility took this kind of damage here, what does it mean for everything else currently collapsing around him? And here is where the verdict stops being a single bad day and starts looking like the final crack in a structure that was already crumbling. Because the courtroom loss didn't land on solid ground, it landed on ground that was already scorched. Sources suggest that within weeks of the trial concluding, Centabel, the African children's charity Harry co-founded with Prince Siso, had filed a defamation claim against him. His own charity, the institution he built, suing the man who built it. That is not a footnote. That is a signal about how completely his relationships have deteriorated, even in spaces he once controlled. Then there is African Parks. Harry had been a board member of the conservation organization since 2017. His departure was not quiet. Questions about his conduct, engagement, and the optics of his involvement had been circulating internally before the exit became public. Arkowell, the foundation he and Meghan positioned as the cornerstone of their independent operation, is by all accounts effectively shuttered. The Netflix deal that was supposed to fund the vision has run its course. Speaking engagements that were meant to replace royal income have quietly dried up. And Invictus, the one project that genuinely earned him cross-partisan goodwill, has seen sponsors withdraw, deliberately and without fanfare, which is precisely the kind of exit that hurts most. Each of these might, on its own, be survivable, but the pattern they collectively form is deliberate distancing. Nobody wants to be publicly associated with someone whose credibility a high court judge has now questioned on the record. The verdict didn't create this situation, but it may have permanently sealed it. So what actually happens next with the money? hat question is sitting unanswered in a London courtroom right now, and the outcome is genuinely more precarious for Harry than most people realize. The costs hearing is still pending. A&L has asked for an interim payment of approximately $10 million, while the full assessment is determined. That figure is almost certainly just the opening position. The indemnity basis request, the mechanism allowing a winning party to recover a greater share of legal expenses than standard rules permit, means the final number could climb significantly higher than anything currently being publicly discussed. And here is where it gets complicated. There were 7 claimants, but sources close to the proceedings suggest the liability question, who actually carries what share of the total bill, is not resolved. Claimants in joint litigation do not automatically split costs equally. The court can apportion based on conduct, on how aggressively each party pressed their case, on who drove the litigation forward. Harry was not a passive participant. He was the most prominent voice, the most publicly combative, and the one whose post-verdict statement almost certainly hardened the court's view of his conduct, which means he may end up carrying a disproportionately heavy share. Then there is the insurance gap. His team's position that coverage extends to $16.2 million has not been formally tested or confirmed by any external authority. Whether that figure holds under scrutiny, whether the policy actually applies to costs ordered on an indemnity basis, whether there are exclusions nobody has publicly acknowledged, all of that remains genuinely open. An appeal is possible, but appeals and costs matters are difficult, expensive, and rarely reverse the fundamental direction of a judgment this comprehensive. The warning Harry received before this ever reached a courtroom, the one he quietly dismissed, was that the evidentiary standard would be impossible to meet, and the financial exposure would be catastrophic if he lost. He lost on every single claim. The person inside the palace who said, "What an idiot," wasn't reacting to the verdict. They were reacting to the fact that everyone who mattered already knew this was coming. And Harry walked in anyway. Harry lost. The Daily Mail won. But the real bill, potentially millions, is still being calculated, and that number could follow Harry across the Atlantic. This was never just a lawsuit. It was a bet he couldn't afford to lose. Who pays next? The miscalculation